This is Earl White, attorney. This is a video about 5 reasons to transfer real estate into a trust. Reason number 1, avoid probate. If you've gone through probate or you know someone that's gone through probate, you know it can be a long, drawn-out, painful experience. This may involve submitting wills and death certificates to the surrogates court, and it becomes public record, so some people may not want that to be on like their personal information to be part of court records. It's, like I mentioned, if there's a lot of assets at play, then it may be more efficient from a legal fees perspective to decide how those assets should be handled while they're living through the trust document. And this way, everything will be efficient as opposed to trying to figure it out on the run after the probate is filed. Then you also avoid potential disputes by putting in the trust. It may be a low likelihood in your family, hopefully it is, but when you go file in surrogates court, you are filing with the court, and people could contest that probate and try to switch in a different executor or administrator. So you can also have that benefit by avoiding probate. Next, reason number 2, creditor protection. Not all types of estates will give you not all types of trusts will give you creditor protection. So more likely than not, you would have to need an irrevocable trust for creditor protection. The reason being, with an irrevocable trust, you've essentially transferred the property as a form of a gift, because you can't get it back. With the revocable trust, you haven't really made a gift because you can revoke it and take the property back at any point. So you could get creditor protection from an irrevocable trust, and that really would make sense if you're anticipating something in the future, a lawsuit in the future, judgments in the future. If you're not anticipating that, maybe it's not important, but if you're not sure, then that could be a good strategy here to avoid potential creditor liability. 3, management of assets. If you're a sophisticated person with real estate, maybe you're an investor, maybe you have multiple properties, and this is your expertise, then you may want to make sure the management of the asset is per your wishes before and after death. With the trust document, you can set forth how you want the property to be managed before you pass away and then also after you pass away. This way, the beneficiaries of the trust, most likely your heirs, are then able to gain the benefits of your good decision making without having them make the decisions after they inherit it, which may not be as good as your decision making when it comes to real estate. 4, confidentiality. When you put it in a trust, there's 2 pieces of confidentiality you'll get. 1, you'll have a deed recorded with the county when you put the real estate into the trust. Therefore, instead of your personal name or your personal address having to be part of the county record, then you can just have the trust information so people can't access your name and specific address. Also, as mentioned earlier, there won't have to be a will probated with the county surrogates court, so that's another way you get extra confidentiality with the trust. 5, tax benefits. A trust, when designed correctly, not always, can offer you significant tax benefits. So, particularly with an irrevocable trust, if you put real estate into an irrevocable trust, it is essentially giving a gift, because you can't withdraw it, so you're essentially giving a gift, and therefore it will count as gift taxes instead of estate taxes after you pass away. So if the gift tax is going to be more favorable than the estate tax, then yes, that can make more sense. Obviously, if the estate tax works out more beneficial than gift tax, maybe you don't want to use that strategy. The other way that the trust can also be used to improve your tax situation is that you can every year give a contribution to a gift to the trust. Currently, as of making this video, there's a $17,000 exclusion for single people and $34,000 gift tax exclusion for married couples. You can give up to that maximum every year if the trust is designed correctly to take advantage of that being a gift. Again, this is where you really need a good estate planning attorney to be able to help guide you on how to properly maximize your tax benefits when it comes to gifts, estate tax, and any other income tax that may be related to items that go into that trust or don't go into that trust.